So to everybody here in the room and also after the recording is published, I'm delighted to welcome you all to our today's IP4OS webinar, which is hosted as usual by Miller International Knowledge, also called MIC. And what is MIC, you might ask yourself? Well, MIC is a research and knowledge consultancy working at the intersection of law, of ethics, and open science. And our mission is to promote responsible research practices, enhance data governance, and support ethical and legal readiness for innovation and knowledge valorization. And this webinar today is part of the IP4OS, so Intellectual Property for Open Science project, which is a European project and initiative that explores how intellectual property systems can enable and protect openness in research and rather than hinder it. And we work to make IP more transparent, fair, and responsibly licensed in the context of open and AI-enabled science. And I'm so happy, dear Reese Richardson, to have you here today as our guest. You are a meta scientist. You work or you focus your work on reproducibility, on bias, and scientific fraud. And you are widely known for uncovering systemic issues in how academic reputations can be manipulated through the misuse of intellectual property registrations. And you have authored over 1,000 publication peer reviews on PubPeer, and you continue to advance integrity and accountability in science. So what else can I say? Yeah, it's now the moment to listen to you again. Thank you so much for joining us so early in the morning, 6 o'clock for you. Thank you very much. The floor is totally yours, and I'm here to assist you. And then we wait for the questions in the chat. Thank you very much. You're muted, Reese. Yeah.
Got it. Thank you so much for the introduction. You can see my slides okay, correct?
Perfect.
Okay, fantastic. Thank you very much for the introduction. I'm flattered. I am very happy to be invited. As you said, my name is Reese Richardson. I am a meta scientist broadly, and one of my main tracks is studying systematic fraud in science and the manipulation of reputations. And I'm here to you today to talk about a specific facet of that involving intellectual property law that we discovered last year, and that we recently published in the International Journal of Education for Educational Integrity. So if there are any questions that you have, you might find the answer in the article, which you can read here, but I'd be happy to answer them at the end of this presentation. So, a brief primer on how we got to now. Well, research in science, scholarly research in general, is very resource intensive. It takes time, it takes money, it takes staff, it takes laboratory space, it takes equipment, and all of these resources go towards resource intensive experiments and analysis. And then traditionally, those experiments will wind up with some results that are supposed to make it into a publication. Dissemination is a core of scientific conduct. And then that publication is then built upon via other work in the same way that it builds upon other work. We formalize that into a system of citations where papers will cite the articles from which they derive their claims, and then those articles cite other articles, and et cetera, et cetera, et cetera. So because science is so resource intensive, there is a lot of competition for how these resources are actually doled out. Some of the ways that this manifests are like who receives grants, who receives funding, who receives jobs, who gets tenure, who gets promotions. And science is a large, complex organism. So while it would be fantastic to rely on expertise to make those decisions, because of the complexity of this organism, over time, we've developed this system of simplifying heuristics by which we use these publications and the citations they receive to go back and evaluate the research and researchers after they've happened, and then decide who gets resources in the future. And again, because science is so complex, these resources are doled out according to quantitative metrics a lot of the time. So literally counting up the publications and the citations that they receive, largely because, we can't read them all. So you might be familiar with a lot of these quantitative heuristics. We have stuff like the H-index and the impact factor. And then basically every university ranking around the world, from stuff based that rank every country in the world, like the US News and World Report or the Shanghai ranking, to rankings that are country specific, like India's National Institutional Ranking Framework. All of these rankings are in some way built off of these quantitative publication heuristics. Many of them are primarily built off of these heuristics, but all of them invariably feature counting publication outputs and counting citations to some degree. And then some universities around the world, particularly in certain countries, like for instance, this was widespread practice in China until it was banned in 2020, will actually award cash bonuses to people that achieve highly cited or high impact papers. Um, and as a result of this system, by which things by which research is evaluated based off of quantitative metrics, and then meeting those quantitative metrics has come to be rewarded, there has evolved this marketplace for cheating your way to those metrics. And this is the industry of academic fraud that we'll be talking about today. Often, this is conceptualized as the idea of a paper mill, which is an organization that is understood to sell pre-written manuscripts, authorship on those manuscripts, data underlying those manuscripts, manipulating peer review, and selling citations to authors. So for instance, here is an advertisement that I found on Facebook. And these are not hard to find. You basically just have to put yourself in the shoes of an academic that is desperate for papers. For some of us, that's going to be a lot easier than others. And just look up keywords like authorship position Scopus, Scopus Index Journal, publication guaranteed. This advertisement is offering up authorship positions for sale on 3 different papers that would eventually go to be published in a Scopus indexed venue. Um, and you can find thousands of advertisements like this across platforms: Facebook, Telegram, WhatsApp, WeChat. It really doesn't matter where you look. These organizations want to be found by academics that are hurting for papers. So this investigation has to do specifically with India. And in India, it's not just that quantitative metrics are used to evaluate, it's that they really form the basis for evaluation at most Indian universities. So for instance, the University Grants Commission, part of the Ministry of Education, which is an organ of the government of India, specifies this points-based system that it recommends that universities use for evaluating candidates and evaluating promotion. So within this points-based system, for instance, to move to a full professor, you need a research score of 120 points. and 10 publications in peer-reviewed or UGC-approved journals. And only recently did the UGC approval process for journals completely change. They abandoned this idea of the UGC CARE list of sanctioned journals that you should publish in. But there are a variety of different ways that you can get those points towards promotion. One of those ways is by publishing articles, scientific articles. So for instance, for faculty in STEM, you can get 12 points per paper if it is published by an international publisher, i.e. one that's outside of India, or rather, this is books, excuse me. You can get points based on the books that you publish. You can see that you can get 8 points per paper if it's in a peer-reviewed or UGC listed journal. And then you can get additional points if that paper is published in a journal that has a high impact factor. And you also get things for if there is startup documentation for your lab, or if you have a memorandum of understanding with a company based in a country other than India. And one of the ways that you can get points is by obtaining patents. So within this base scheme, you can actually get 10 points for a patent that is awarded in a country outside of India and 7 points for an Indian patent. So we were monitoring fora in which paper mill advertisements go up on Telegram and WhatsApp. Here's an advertisement that went up on LinkedIn. And we noticed that alongside many of the advertisements that we were familiar with for authorship positions and editorship positions on books and peer-reviewed articles, we started seeing advertisements for what were called UK design patents. So you can see in this advertisement, they're saying that this patent will be granted in 3 to 4 weeks, that you can pay this many rupees for each applicant position on the patents, and that this is what the patent is called. And then often these advertisements will explicitly link these publications to things like API, which means academic performance indicator. This is what the scoring system, the points-based scoring system, is known as. It links it to accreditation of the university. And indeed, things like patents are counted in the National Institutional Ranking Framework of India. So we were looking at a lot of these advertisements, like this one that you see here, where these design patents are advertised alongside authorship positions on IEEE conferences and book publications. And we were actually able to link a lot of these advertised titles to design registrations that were actually published and granted in the UK. So for instance, on this last advertisement, you can see smart garbage bin with biogas generator. Already a couple of positions had been booked on it. And then shortly after this advertisement went up, you can see that a design registration for smart garbage bin with biogas generator was filed and then shortly after granted in the UK. So for the non-IP professionals that are watching, we have to make a quick distinction between utility patents and design patents. So utility patents generally cover the way that something functions. So you might get a utility patent on the formula for Coca-Cola or how Coca-Cola is actually made. Whereas design patents cover the way that something appears. So these can cover shape, form, pattern, but they have little to do with functionality. So for instance, this patent on the right has to do with the form of the specific part on the original iPhone. What a design registration is, it's similar to a design patent, but it's actually not a patent at all. it is granted without ex ante novelty review. And it took us inviting a an expert in design law, Sarah Fackrell of the Kent College of Law at the Illinois Institute of Technology, to understand that when these advertisements were offering patents, they were not offering actual patents at all. And in the UK, these design registrations are actually granted very, very quickly. And we'll get to that in a second. But more or less automatically. They're basically just checked for profanity, and then they are sort of granted. Again, they do not undergo ex ante novelty review like a patent would. Um, and then if you look at the content of these registrations, they'll have names like AI-based humanoid for visitor identification, smart shoe for visually impaired. A lot of them are AI-based. And if this doesn't give you an idea of the sorts of designs that are being filed for genuine intellectual property protections, um, they're not very good. Uh, they they look like children made them, and we'll return to that point in a second. Here's a few more examples. You will see a lot of humanoid robots. You'll see a lot of keywords like blockchain, AI, and the titles will often emphasize functionality. So we wanted to track and see how big this problem might be, or how large this practice might be. And using those advertisements that I mentioned earlier, we were able to link two companies that were filing these design registrations in the UK to these advertisements that have taken place. So we'll call them Firm A and Firm E. In the UK, you need a representative to file on your behalf. So both of these companies started filing design registrations on behalf of clients in 2023. And they had filed close to 2,000 registrations since. And we only had collected data up to 2024, in part because the data was so difficult to obtain. We literally had to download these registrations 150 at a time from Design View, which is a search service for design registrations and design patents. Um, and then we saw, again, like as you can see on the right, a lot of these registrations were talking about how they were AI-based devices for detection of whatever, or they involved machine learning, or they involved cancer, or solar cells, or farming, or whatnot. Uh, so design patents and registrations are collected under the Locarno designation system. And we counted up how many of these design registrations that we collected fell into particular categories. The most common class was apparatuses for doctors, hospitals, and laboratories. So a lot of the time, these were medical devices. And when I say medical devices, I mean stuff like the smart shoe for visually impaired, stuff that obviously is not a real product, but they're behaving as if it is. And as I alluded to previously, these applications tend to be approved quite quickly. Again, they do not undergo any novelty review like a patent. So you can effectively register just about any design, and it can be granted. And in fact, I was sort of misleading earlier when I was talking about a design registration being filed for smart garbage bin with biogas generator, because there were actually two different registrations filed for smart garbage bin with biogas generator. And they used the same images as one another, but they were filed on behalf of different sets of clients. Um, Here is another example of this. These are 5 different designs granted in late 2023 and early 2024 that all purport to be different devices, but they are using the same images as one another. This was mostly concentrated between only one of the firms that we looked at. So a quarter of the firms filed by one of those firms were actually using the exact same images as another design. Uh, so this might invalidate the designs if you were to bring this evidence to a judge in the UK, which is the process by which design registrations are invalidated. But this does not stop them from getting genuine intellectual property protections through the UK design registration systems. So among these design registrations, almost all of the applicants are Indian academics. I say patents here, but really I mean design registrations. Again, they're not patents. They're telling people that they're patents, and they are not. And we found that many of them actually listed applicants that were the universities that these Indian academics worked at. And as if this really wasn't plainly spelled out from the beginning, the 2 most common applicants on registered designs that we were able to identify were Indian academics that founded a consultancy that advertised that they could get UK design registrations to people that were willing to pay for them. So we wanted to expand our search and find out just how many firms were operating in this space. So to do that, we took all of the design registrations that were filed in the most common Locarno class that we saw for firms A and firm E, and that was the medical devices class. And we took just the top 15. So here you'll see firm A and firm E, and then you'll also see 13 other firms that we identified. And you'll notice here that we classify these firms based on whether they started filing design registrations before January 1st of 2023 or whether they started filing design registrations after January 1st. And you'll see why this was useful to separate out which firms might be legitimate and which firms might be suspicious. Because the character of the designs that they filed were completely different based off of this arbitrary designation alone. So for one, the designs registered by what we call legitimate firms, which are these blue ones here, the ones that started filing before January 2023, tended to be filed on behalf of just a couple of applicants. So you'd file something for Nike and maybe one other person at Nike. You would not file on behalf of up to 10 people. But this is something that regularly happened for the suspicious firms, as they were filing these design registrations on behalf of up to 10 Indian academics, and often more than that. Moreover, the titles of the registration were completely different. I'll move forward one slide to give you an idea of what that is. For design registrations, typically the title is mostly a formality. And I say title, but really I mean product indication, speaking in the parlance here. So they'll say something like lever, helmets, control panel, and they will just be purely descriptive. Whereas the suspicious firms that we were looking at would file these long, flowery titles like AI-driven interface for predictive healthcare revenue cycle management and billing. Again, these are design registrations. They do not cover the functionality of the product being described. They literally just cover how it works. So the applicant is, or how it looks. The applicant is under no obligation to demonstrate that this is an actual working product or has a novel working mechanism. You can basically register anything that has a drawing associated with it. Um, and one interesting thing that we found, although we didn't look much into this, is that the suspicious firms seemed to have a much quicker turnaround time between the filing of a design registration and when that design registration was granted than the legitimate firms. And again, we didn't look too much into this. This could be because the suspicious firms were filing in particular areas that tended to have more reviewers or that tended to be granted faster overall. But you can see here that there is a much shorter tail on this distribution of approval times for the suspicious firms than for the legitimate firms. Um, and then these product indications, what I'm calling here titles on the slide, tended to be shared between different firms very often. So this diagram shows each firm as a circle, and then it shows links between the firms based on how often they filed design registrations with product indications that were completely identical to one another. So you might expect this to happen if you are filing design registrations that have titles like helmets or golf putter. Um, but these design registrations had these long drawn out titles, so it's incredibly unlikely that these product indications would be filed having the exact same structure and text uh, by random chance, just saying that these people came up with them organically. So we strongly suspect that all of the firms that we identify are in fact coming from the same places. One of the firms that we identified, which we also suspect is using the identity of a legitimate business in the UK, based in the same business park that they claim their address is, and with the same name, uh, was repeatedly filing designs that were based off of 3D models that were already publicly available online. So I mentioned that many of these designs look like they were made by children, and that's probably because they were. So here is an instance of a design registration that was filed in the UK. You can see the number down there for a device treadmill walking machine. And you can find almost the exact same model online published earlier. You could also find stuff like this robotic hand sorting of VLSI devices. This one is particularly interesting because there is an existing product marketed around the world, including in the UK, that has this exact design. It's a very from a very popular robotics company called KUKA. And we found lots of instances of this where they were filing design registrations that seemed to be entirely based off of 3D models that had just been cribbed somewhere from online. And now I want to get to the punchline of all of this. One of my favorite ones that I found was called Designing an Artificial Intelligence Powered Skin Cancer Inspection Device with Design Thinking. Uh, so I want you to picture what this device might look like, uh, just as an exercise. Picture what this incredibly suggestive title might might conjure up. I'm willing to bet that it was not this, and you are not picturing this. This is indeed a 3D model of a Glock pistol with a screen attached. And again, this is the sort of character that you see being filed over and over and over again. And we stopped collecting data in the middle of 2024, but this practice has continued. And indeed, based off of a rough estimate, it's probably doubled in size since then. And who knows how many different identities are being used to file these design registrations in the UK. So we went to the website of the firm that was owned by the two most common applicants of these design registrations. Indeed, the firm that was offering to sell UK design patents. And on that website, they advertised a number of different services, basically anything that could be used for the points-based system for promotion or for bumping up university rankings in India was for sale on their site. And you can see that it is not just these UK design patents, which are really design registrations, but article writing, thesis writing, startup documentation. We have evidence that they were setting up fake companies in the UK solely so that these companies could file memoranda of understanding with laboratories in India to bump up their rankings. You can see that they explicitly mention ranking systems and accreditation systems. And we also, in our paper, we show in the supplement a lot of examples of intellectual property protections that these firms were advertising outside of the UK, not just design registrations, but also utility models granted in Germany, copyright registrations granted in Canada, design registrations granted in India and Australia. Really, all of these systems are vulnerable to intrusion by whatever we want to call these organizations. We call them paper mills traditionally because that's how we got to them, through the services that they offer to manipulate academic publishing. But clearly that name does not capture the full scope of activities that that can fall under the same roof. So, as I said, you can read more about these organizations and more about the things that we found in our publication on the topic, which you can access here. I also wanted to give a shout out to a project that I am involved with called the Collection of Open Science Integrity Guides. COSIG is an open source project that basically the goal is to put together a large, comprehensive starting point for doing post-publication peer review. And indeed, it's been put together by many of the people that regularly work in this space about academic reputation manipulation, and it shares many different methods by which we spot these things. But yeah, that's about all I have for you today. I want to thank you all for listening. I want to thank my co-authors for their work on the manuscript, and I encourage you to check out their work as well. And I'm happy to take any questions that you might have.
Wow, Reese, I'm really impressed, and I don't know, I'm between laughing and unbelief. Yeah, I mean, this is crazy, but I don't want to waste too much time with my thoughts because we already have two questions in the chat, and I will read now the first one to you. So the first question is, does this UK registration design system exist only in the UK?
It does not, no. Broadly around the world, there are two different types of systems by which intellectual property protections are granted to designs. There's the design patent system, by which applications undergo ex ante novelty review.
Mhm.
So this is the case in the United States, for instance. And then there are design registration systems, uh, where things are more or less granted only with formal checks, and not undergoing any sort of novelty review. So, if I'm not mistaken, Australia has a design registration system. The UK has a design registration system. India has a design registration system. Uh, and yeah, it's not just design registrations either. I alluded to the idea of utility models in places like Germany. And they sort of operate similarly, where it gives a lot of the same protections that you would expect from a utility patent, but it's granted without ex ante novelty review.
Mm.
Um, so yeah, so these design registration systems take place just about anywhere.
Mhm.
And indeed, these firms will post advertisements that say, we've been granted a design patent. And indeed, they have been granted an actual patent that did undergo novelty review in a jurisdiction that grants design patents. So they're not restricted to just operating in jurisdictions that have this design registration system. Um, but it is a lot more convenient for them. It's a lot easier to offer up a design registration that gets granted in like 10 days than it is to offer up a peer-reviewed publication in a high impact outlet that may or may not wind up in that outlet, and you may or may not be able to secure the right peer reviewers, the right editor to get it published. And it takes a lot of time to get it published as well. So this is a rather attractive market, both for the businesses offering these services as well as their clientele.
Thank you so much for clarifying this. The second question is, do you suspect that AI activities are behind these suspicious companies filing design patents?
That's a good question. So,
Mm.
um, we showed that this practice started before the advent of large generative artificial intelligence models. Um, or rather, back when they were not as good as they are today. Um, and I don't suspect that AI is used in a lot of these, other than, just winding up in the title, right? Um, Largely, these models, I believe, are just taken from models that are publicly available online or just sort of cribbed together. I suspect that students are making a lot of these models in classes that are about using computer-assisted design software. Um, but yeah, it certainly could be the case that that AI is used to accelerate this process. And my colleague, Michael Draper, has written about the role of AI in intellectual property protections in the UK and the extent to which um, designs and intellectual property that is created by a artificial intelligence system will actually have genuine protections. But these are open questions all around the world.
Very interesting. Thank you so much, Reese. I would then jump to the next question, which is, yeah, I had the same question while listening to you. What would be your suggestions on how to change these bad research practices? Oh, where to
Mhm.
start, huh?
Right.
Yeah.
Um, I think that a lot of people's first instinct is we need to make our systems less vulnerable to manipulation. So it's could be the case that, like, UK design registrations, the design registration system could be overhauled, or at least reformed to check against these practices, like to make sure that the company filing it actually exists or has been approved to act as a representative for people in the UK. In fact, many of the companies or several of the firms that we identified uh, only had an address on paper. Like they were registered at one of those houses that has like 5,000 businesses registered to them. So, in order to protect the intellectual property system from exploitation, you could imagine reforming the system. Uh, However, that really does not end the scheme. These are large businesses that have been propped up based off of these practices. And clearly they have a lot of clients. If one system is made less vulnerable to exploitation, they will adapt and move to another. And we see lots of examples of adaptive behavior by companies that operate in the market for academic reputation manipulation. I believe that the best way to counteract this behavior is to ditch these quantitative metrics entirely. If academic promotion systems in India were reformed so that they were not based on just counting publications. And indeed, there's been a lot of criticism levied by Indian academics against the National Institutional Ranking Framework, which is widely seen as rewarding manipulation of metrics. If these systems go away, um, then so too does the demand for these products. And that's really what we need to check here. The same goes for publications. As long as publications and citations are what counts, the standards for what makes it into the peer-reviewed literature will continue to drop.
Yeah, so it would be really like what I understand, a lobby for a change of the system, right? And that's, by the way, not the first time that I hear that. Also, European researchers now are saying more and more that maybe we should start changing the system of making our research valuable.
Mm.
And I would now love to just jump in with one of my questions,
Mm.
because being a lawyer, I've also asking myself, and I would love to hear your view on this. If do you think this is rather this phenomenon is rather or should be rather considered a form of scientific misconduct, or is it more about regulatory loopholes?
Mm. Good question. I won't pretend to know anything about law and regulatory law and IP protections. Um, but I think it can be considered an example of both. So I mentioned this earlier, but these what we call paper mills will offer many different services under the same roof. Many of them are not restricted to just what are traditionally considered academic endeavors. Um, and we also know that these businesses likely operate out of the same places that are selling essays, that are selling exams. And across a wide range of industries, there is a market for credential fraud. Um, so for nursing registration, there are businesses that offer to forge documents for you. There are businesses that offer to forge documents for just about any type of certification that you can get anywhere if there is sufficient demand for it. So I think it's a mix of both, and we really should I hope that we can get towards a better, more comprehensive name for this. I might suggest the market for reputation manipulation broadly, or the market for credential fraud, could broadly describe these things, but really we don't have like a catch-all term that gets everything that's going on here.
I thought spontaneously like research mill or scientific mill. Yeah, but you're absolutely right.
Right. Yeah,
Yeah,
but that's the thing. That's the thing
yeah.
is they're not necessarily strictly about science as well. So for
Mm,
instance, many of I have a colleague, Anna Balkina, that has exposed a lot of paper mills across Europe and former Soviet countries. And many times uh they're offering articles in law and in the
mm,
humanities and in literature. So it's
mm,
really anything scholarly. Any term that we try to come up for it is going to be lacking in some way.
mm,
I tend to call them paper mills just because that's how we arrived at it.
mm.
Was how they manipulate academic papers. But yeah.
Yeah. Oh, there was now a question to me. Yes, yeah, Julia is asking if these procedures that you have been describing, Reese, if they're illegal in some countries. And absolutely, yeah. So these procedures that you have been describing before me jumping in, calling it, naming it research mills or science mills. Yeah, you're absolutely right, Julia. Thank you for pointing this out.
I would
And
love to hear more about that because
yeah,
we
yeah,
were one open question is like, how do we stop this?
yeah.
In the news coverage that we got about this paper,
Mm,
the UK design registration or the UK Intellectual Property Office was quite dismissive of these
mm,
concerns.
mm,
And they said things like, we it's regular procedure to sell intellectual property rights. And indeed, like you can, sell the right the the ownership of a patent, right?
mm, mm.
Um so I'm and moreover, it costs like I couldn't tell you the exact numbers, but
Mm,
it costs like £50 to file 10 of these design registrations at once in the UK.
mhm,
And it costs a similar amount of money to file one document saying that this design registration is should be invalidated.
mm.
So there are lots, and then that has to be signed by a judge, right?
Yeah,
A judge has to find that that has standing.
yeah, yeah.
So, and then if the registration was invalidated, what does that
Mm,
actually do if
mm.
these registrations continue to flood in and gum up the system?
Yeah,
Plus, like the person already has a certificate, right? It like the damage is done.
yeah,
Um, so yeah, yeah, I would love to know more if people have ideas about
yeah.
how this could be addressed and what recourse exists for this.
Wow, so count us in. I think we would be happy to be on board. And I think one of the biggest issues here is also the lack of knowledge from yeah, from my colleagues, yeah, because legally I do understand that the formality is fulfilled, yeah. It's more the material, the content, which is here wrong. But I would love to go back to the questions here in the chat from our
Mhm.
colleague from Pakistan. Sorry from always stating that you're from Pakistan, but I'm so happy that you made your way here. Dr. Savar Said, who is asking how you can make our existence meaningful while reporting a fraud in science. Yeah.
Mhm.
When I do, I always face a lot of resistance. In fact, just today, I received an inquiry report about misconduct in science by my own student. I reported to Ivan. The community decided against me. That is funny. Okay, so this is rather a comment, yeah, confirming that it's rather difficult to
Mhm.
fight, yeah, or to combat this system. So
Yeah,
yeah.
and uh what what Saba is talking about is very common. And it's you do receive a lot of pushback. Not only because you're questioning the reputations and credentials of fellow academics, um, but also because though there's money to be made here, right? So I myself have received a lot of hate online from people whose papers I've helped to have retracted. Um, I've also received complaints against me leveled against my university for some of the research that I've done and some of the stuff that I've done. Um, and indeed, many people choose to navigate this space anonymously. So for instance, the platform PubPeer, where people regularly leave comments about scientific articles, um, uh, where they show observations of impropriety, you can leave comments pseudonymously, and that's largely as a protection against retaliation. Um, but it is a constant threat. What I hope by engaging in this work under my own name and from within uh, academia is that people can feel more comfortable uh, addressing these things and studying them as a legitimate object of scientific inquiry. Traditionally, this has been, or in the past, this has largely been left to independent volunteers who are very brave to be doing that, and to journalists. Um, and really, if we want to see change, we need buy-in from people from within the academic establishment as well. So I'm hoping that this work can do that, but I share Dr. Saeed's concerns that this is really fraught work, and I don't have a solution for how to maintain how to maintain dignity while doing it.
Well, I think, Reese, you are already contributing a big part, yeah, in combating the fraud. So thank you for this, yeah, because it can, as you just stated, it's can be painful, yeah, and it also hurts. So when you receive these messages, it's not easy. So really, thank you so much that you're doing this. And
Thank you for listening.
yeah, no. Again, thank you for being here so early in the morning. And maybe there is one last question by Marie related to how to change the practices. So the question is, would that be an idea to expand the requirements to IP, this design registration? So she's referring to the design registration, and to
Hmm.
establish a long-term monitoring of these products really are being produced by the firm. Oh yeah, okay, I get the question. Yeah, otherwise the patent will be rejected. So it's rather, I think, a question for UK, right? If
Hmm.
they would change their regulation. Yeah, it leads us back to what we just tackled earlier, right? It's really on both sides. So from within the research environment, but also the regulatory actors, right? Have to,
Yeah.
it has to go hand in hand, I think.
Yeah, and I can see like a lot of people who advocate for design registration systems I've learned are adamant that it is essential that they do not have this novelty review mechanism.
Mm.
And that it's much preferable to design patents. And I know that there are scholars that feel differently, and maybe there are more scholars that feel differently. Now that we've shown that these systems can and are abused. Um, but that's really a conversation that needs to be had is
Mm.
how can we how can we reform these systems so that they are less susceptible to abuse? Um, how can we save the reputation of these systems so that people feel more comfortable actually getting intellectual property protections through them? Um, all of these are very relevant questions, and it might be like a long-term monitoring situation. It might be a reformed certification system for who's actually filing the design registrations, etc. But um, uh, on my end, I'm open to all ideas. Again, I'm no lawyer, let alone a lawyer in the UK, but to me that seems entirely reasonable.
Again, you can count on us. Yeah. Happy to enter this good fight. Yeah. And yeah, Dr. Said is confirming, thanking you that she's one of your, or he, sorry, apologies, one of your followers in reporting bad science. This is great to know, I think.
Thank you
Yeah.
very much. I really appreciate that.
Yeah, I think everybody that we are here and also will listen to you in the future, the recording, we are supporting you. I would suggest now to close this today's webinar. I don't know if there's anything else you would like to tell us or to appeal on. Oh, yeah.
No, this has been fantastic.
Mm,
You can find more stuff that I've written
mhm,
at reeserichardson.blog.
mhm.
I put some contact information in the slides as well. And like I said, check out COSIG at cosig.net if you're interested in post-publication peer review. It's a fantastic resource, and we're also looking for people to contribute to it. So yeah, thank you so much for listening. I really appreciate having been invited.
Reese, again, thank you so much. What a start in the day, in your day. I hope it will continue, yeah, as impactful as it has started for you. Maybe now you can again relax a little bit, yeah. But again, thank you so much for joining us, and to all the others, the same. Thank you for joining us. There will be a transcript also on our website, the recording, and yeah, let's continue this good fight. I think it's very important for everybody. Thank you so much. Have a great
Thank
day,
you.
everybody. Bye. Bye.